All right, it is 12:02, so I think it's time to get going. Thanks for joining today, everybody. My name is Ross. I'm a librarian with the King County Law Library. Today, we are taking a look at minor guardianship. This slide says technically it was created in March 2022, but I was creating or making updates to this presentation until this morning. It's a constantly evolving thing, and let's just say that the only thing I didn't update is this March 2022 bit. So we're talking about minor guardianship today. I'm going to be talking for about 40 minutes, looking at how the law changed a few years ago, talking about changes since then to procedure. We're going to be looking at the forms and processes that kick off minor guardianship. So we're talking about what it is, how you do it, and then towards the end of the hour, after about 40 minutes, I also have Nadia Simpson on the call, who is in Ex Parte, and the Ex Parte department oversees guardianship, and she's a font of knowledge. So we're going to have Q&A at the end of the hour. The idea being, ask questions. In Zoom here, there's a Q&A section. Ask questions as you think of them. I'm kind of going to be plowing through my section, but then at the end of the hour, we're going to be going through all that Q&A. So ask so you don't forget, but we're going to be getting to the questions actually towards the end of the hour. So with that out of the way, let's dive into what is minor guardianship. I take that back because the next slide is in fact about the law library. We have locations in both the Seattle and Kent courthouses. We offer books, of course, databases, including many of those can be accessed at home. Go to our website, which is kcll.org, to look at our databases. We also make videos and infographics, flyers, different things to help you understand court processes in action. And lastly, we work with attorneys to put together form packets. So these include things like how to start a civil lawsuit. So that has the instructions on starting a civil lawsuit, as well as the forms, which are not provided by the state or the county for that. We don't have any kind of in-house packets on guardianship yet, though. We do print on demand, though. So if folks come into the courthouse and you need the forms for starting a guardianship action, the family law facilitators have put that together, and we'll be talking about that a little bit later in the hour. But we do print on demand. So the forms, the videos, the infographics, all of that can be accessed online at kcll.org. We do a lot more than that, of course, but if you're curious, if you need our help, give us a call, email us, come into the library, and we're happy to help. So here's an overview of what we're going to be talking about today. We're starting with a very broad view of the topic, and then we're going to be getting more into the nuts and bolts as we go along. Quick note on some of the variations to procedure that we're not going to be covering today. So if you're hoping to hear about this, know now we won't be talking about if you're trying to take guardianship of, as the law says, of a guardianship of an Indian child or anyone who may be an Indian child. That could probably be its own class, and there's a slew of additional forms that are involved in that. So that's outside the realm of what we're talking about today. We're also not going to be talking specifically about how to change or terminate a guardianship, but there are resources that I'll allude to that handle that. I'm also not going to be talking about standby guardianship. But like it says on the page, we are talking about what is guardianship, what changed recently, the differences between emergency and full minor guardianship, and then also responding to guardianship. There are slides for Zoom and e-filing and scheduling hearings. Some of this, with the COVID protocols being around for so many years now, I think we can probably skip over how to use Zoom because you're here right now. So, but let's get into the substance of it. Oh, and a quick disclaimer is that I'm not a lawyer. I can't give legal advice. I have a master's in library science. This presentation is a synthesis of many existing resources that are out there on guardianship. But it's a very new part of the law. It's still evolving, seemingly often. But because this is a complicated and evolving subject matter, and I can't give legal advice, you may need to consult with an attorney yourself. So starting, like I said, with a very broad view of the subject, if you want to know what the basis for everything minor guardianship related is, you can read the statutes. So those are available online. If you type into Google RCW, the Revised Code of Washington, if you type in RCW 11.130, you will find this section. How practical is this? Well, I have a hard time parsing statutes. It's not written in plain English per se, but this is the final authority for the law. So if you're wondering what the law is on minor guardianship, this is where you need to go. There are other online resources as well. So like I said, this is a new set of laws. I'm drawing from several different resources which already exist. So some good ones are on this website, Washington Law Help. I'm not sure if you can see my mouse right now, but Washington Law Helps has some really good information on their site, written by attorneys as kind of a comprehensive guide on how to do this. And now I'm worrying if this is simply just not my updated file, because it says coming soon for the Family Law Facilitators, where in fact, the Family Law Facilitators very much have their guides for which forms to fill out. And I thought I had updated that. But do know that the Family Law Facilitators have guides on their, it's the Family Law Instructions webpage. If you Google Family Law Instructions, at the very bottom of the page, there's this whole section on minor guardianship. The forms that are listed, I link here to the state forms, the county forms. These forms are important. We're going to be talking about these forms kind of one by one later on, but it's often more helpful to have something like Washington Law Help or the Family Law Facilitators, where they list all the forms out in one place and then they link to the forms, or they have them all in one form packet, instead of going to the state website and trying to piece together yourself, do I need this form? Do I need that form? I would send you to one of those kind of secondary resources at the bottom of the page first before going to the state and county sites, but do know that those are available. So what is minor guardianship? If you're in this class, you probably have a good idea, but just in case, minor guardianship is a court process that lets someone take care of a child who isn't theirs, like a parent might. This process used to be called non-parental custody. They've done away with that. It's now called minor guardianship. So minor guardianship is a court process that authorizes someone to take care of a child who is not their own. Guardians are given the right to do things that a parent generally would. And those legal rights are very similar to that of parents. You might be wondering how minor guardianship differs with legal adoption. To me, they sound very similar. Simply, it has to do with parental rights. In adoption, parental rights are basically totally terminated. But there are other major differences, but it has to do with parental rights and things like getting child support, things like that. So this is kind of all lifted straight from the statutes. So the courts can appoint a guardian under a few circumstances that are listed here. Basically, if the parent agrees to the guardianship, well, guardianship can happen. If the parental rights have been terminated anyway, well, guardianship, that door is open. And lastly, there's this third bit that says there is clear and convincing evidence that no parent of the minor is willing or able to exercise parenting functions as defined by the statute right there. So here are some of the changes that happened back in 2021. Like I said, it was basically a complete overhaul, so most of it changed. But the big ones, as far as I'm concerned, is that now objecting parents, if it's like a contested minor guardianship case, they can get a free lawyer to represent them. That's pretty big. There's also more notifying happening when this is actually underway. We'll be talking about who has to be served, who has to be notified in subsequent slides. But I think that was a pretty significant change in 2021. And lastly, the process for getting orders right away is different than it was before this overhaul. And we're going to be talking about that in subsequent slides as well. So the process for getting guardianship right away is different than it was a couple years ago. If you're wanting to take guardianship of a child or appoint someone else to do that right away, there are procedures for doing that under both minor guardianship and emergency minor guardianship. So minor guardianship, the kind of full standard minor guardianship, it's pretty much permanent until the child turns 18. But it does take about 60 days to get going. So there are ways, like an immediate order, to make things happen more quickly under kind of more dire circumstances that we'll be talking about. This is contrasted, minor guardianship is contrasted with emergency minor guardianship, where the idea is that the emergency guardianship is going to last basically up to 60 days. It can be extended another 60 days, so 120 days in total, but that's not a given. And the thing that I hear in the courthouse is that if you know that you need the full guardianship, if you know that it's going to be more than 120 days, more than 60 days, the minor guardianship is more so what you're looking for. Emergency, there are lots of situations where you would want that, but it's kind of much more limited. You know, there's that very acute time scale attached to it. So here is a slide that this is just kind of the cheat sheet, I would say. If you're wondering about the process for how minor guardianship actions move through the court and what is involved and what forms are necessary, you can do no better than reading LCR 98.22. If you type into Google King County LCR 98.22, specifically seeking out like the red line version that is available on the court's webpage, and I took a screenshot right here. You can't do much better because it spells things out very, very clearly about the order that things need to happen, how and why they might happen. A lot of what I'll be speaking about is derived from this local civil rule 98.22. Then for the forms, like I mentioned, the family law facilitators do have this laid out on the family law instructions page. So if you navigate to this page, these are a list. So like a contested minor guardianship, you open that up and it's going to tell you exactly what forms to do. So between having the process, the kind of big picture from LCR 98.22, and exactly what forms you need to file via the Family Law Facilitators Guide, you should have a pretty good idea of what to do, at least to get this started. Of course, acting as guardian to a child involves a bit more than this on its own. But in terms of being a librarian and offering resources, I think you can't do any better than these two. So here's the general flow for minor guardianship and emergency minor guardianship in general. This is kind of the condensed version. I'm going to be getting more into the intricacies between these two in subsequent slides, but just to give you a basic understanding off the bat, what you're doing is completing the slew of initial forms that you can find on the Family Law Facilitator's website, filling those out. You're going to be making copies of those filled out versions, filing the originals with the Superior Court Clerks, scheduling hearings, what kind of hearings and how you schedule them. We'll be talking about them, and then after that, giving notice, doing service of process, and finally going to any hearings that you have to do. You know, what hearings do I have to do? A lot of that is derived or at least discussed in LCR 98.22. So let's go to the next slide and look at specifically for emergency minor guardianship, how this is kind of beefed up. So I acknowledge that this is kind of complicated for one slide, but I just wanted to fit it all. And I'm going to be breaking down this kind of step by step as we go. And a reminder that emergency guardianship is for when you need short-term guardianship, 60 days, maybe 120 days. If you want short, immediate and long-term guardianship, that's where you're looking at the full minor guardianship, and we'll be explaining that next. But right now, we're just talking about emergency minor guardianship. The first decision that you'll have to make is whether you need an immediate order. Usually the first hearing that you would have would be like a week or two, something like that, after filing. But if there's immediate risk to the child's health or safety, you can file for an immediate order. So that's just a couple extra forms. So let's get into forms. Let's talk about what they look like and what you'll be filing. So the initial forms for submitting it for emergency guardianship, first and foremost, you have the petition. A petition, generally speaking, lots of court cases, is that the main one that's going to kick it off. And that's no different here in my emergency minor guardianship. Petition is kind of the main one in a way. This document is going to be you're going to be identifying the child in need of guardianship, the person who is petitioning the court, and also the intended guardian, and why guardianship is necessary. There's also the personal information form. That's a county-specific form. Then we're looking at the criminal history forms and the DCYF informational forms. So these are kind of just extra reports. For the criminal history side, you're going to be getting your watch report, or the watch report for the guardian. This is the Washington Access to Criminal History report. So that's found through the Washington State Patrol. And then you'll be filling out the cover sheet for it and putting that on top of the report. You'll also be submitting a motion and order to DCYF, the Department of Children, Youth, and Families. And so they're going to be releasing information. So you'll be submitting these forms. And then there's also the two forms related to notice, the notice of hearing and the attachment form. The notice attachment to the notice of hearing, it helps you figure out who has to be served, which service serves the process, kind of a strict court requirement, and then also who simply needs to be provided notice. Notice and service are two different things. We'll be talking about how they differ a little bit later on. The notice of hearing itself is letting the people who you're serving and notifying know that the guardianship hearing is happening, and it's pretty straightforward as far as these things go. Here are the forms that I mentioned earlier that deal with immediate motions and orders. So while the emergency guardian process, again, is the short-term option, it still takes some time to get set up. Sometimes you need to move faster. So from the court rule, it says a party, this is LCR 98.22, keep beating that drum, but it says a party may file a motion for immediate order either at the same time as filing a minor guardianship petition or an emergency minor guardianship petition. The motion for immediate order shall be heard in the Ex Parte department according to their emergency hearing process as described on their website. And then the return hearing will be set for the assigned judge for the first Friday that provides at least 3 calendar days notice to responding parents. The moving party shall submit a proposed immediate order as well as the motion with that hearing notice as well. So those are kind of the emergency, if you're doing emergency minor guardianship, those are the initial forms. So you're going to be filling those out and making copies for yourself because you're filing the original, but also for copies for everybody that you need to serve or notify, which again, more on that later. But you'll make copies for all those people because you're filing the originals with the clerk. So taken all together thus far, from emergency minor guardianship, you should know which forms you need, that you fill them out, and then you file the originals. And so this is kind of a condensed version of what I was just saying, where there's for emergency minor guardianship with full notice, you're filling out these forms, doing the notice of hearing, serving copies, and then attending the return hearing. Whereas for immediate orders, there's those immediate motion and order forms, as well as the notice that we talked about a couple slides ago. So here is just something that I wanted to plug. This is from the library site, if you go to kcll.org, there's a tab that says court hearings. And then under that, there's some information on scheduling ex parte hearings. So I'm going to drag over my webpage actually onto the screen so you can see our website. As you scroll down, there's a section for court hearings. And we have guides for how to schedule family law hearings and ex parte hearings. So you can click to actually schedule and get taken to the scheduling tool. Or if you click this main image, there's a step-by-step guide of how to, well, first navigate to that website, which you're already on, and then how to actually use the calendar availability tool to look at how to schedule your hearing. I just wanted to make sure that people were aware that we have that on our website. So that was emergency minor guardianship. Now we're going to be moving on to, kind of standard, the main minor guardianship. It's largely similar. You're going to be completing the initial forms, making copies, filing, serving the parties, and then attending a hearing. Realistically, though, the most practical advice is to complete the initial forms, which, again, Family Law Facilitator website has that. File them with the clerk's office, and why that's the most important thing is because once you start it, you're going to be given a great document that the clerks and ex parte have called minor guardianship, what to do next. And what this is kind of a step-by-step of what's required for you after that moment. We're going to be talking about some of that, but I think just for you to know, get the forms from the family law facilitators, follow 98.22 procedure-wise. You should be in a good place. But let's take a look at this. So there are quite a few forms needed for starting the case. So first you have the petition, which is similar to the emergency petition. There's also a summons, and then there's the notice of hearing, the notice document. So these, the notice document, these let people who need to be served or notified know that a hearing is taking place. There's also a declaration, which is basically where the case is made that guardianship is necessary. Of course, guardianship of a minor is a big deal, so the courts have to be convinced, why it's necessary, and that's one of the purposes of that form. There's also the same criminal history and DCYF forms that we saw before, making sure the child's going into a safe environment. And here are the same forms that we looked at earlier for the immediate motions and orders. Again, I'm going to be reading from LCR 98.22. It says a party may file a motion for immediate order either at the same time as filing the petition or after filing the petition. The motion for immediate order is heard in the ex parte department according to the emergency hearing process described on their website. The return hearing will be set before the assigned judge on the first Friday that provides at least 3 calendar days notice to the responding parents. And of course, the motion is being accompanied by the order as well as the notice documents. Here are some other kind of optional initial forms. It's a motion in order to withhold certain documents from the minor. You'd use these because if the child is over 12, as we'll see, they need to be served as well. So, if we're talking about the petition, the declaration, it's possible that these forms or, even later documents could have information that could, kind of psychically hurt or traumatize the child. Some information doesn't need to reach them. The motion and order work as a pair to prevent service of those specific forms on the child. Once you're filing these and you have a hearing date, you'll be filling out this notice of hearing. Again, you're looking at that case schedule order that you get from the clerk, as well as that what to do next document to know what's happening next. And of course, you'll have the case schedule to fill out the notice of hearing because otherwise you wouldn't know when the hearing is. But that way you can serve the other parties. And so with that, who needs to be served? So service of process is an official court way to let someone know that a case is happening. you probably seen it in movies where someone jumps out of the bushes and they say, "You've been served." For minor guardianship cases, a few people need to be served, and here I've copy and pasted from the statutes. Basically, the minor, if they're 12 or older, their parents or next of kin, or any current guardian or person with non-parental custody, or whoever it says any other person the court determines. I'll talk a little bit about what service process entails a little bit later, but this is who needs to be served. You can contrast that with who needs to be simply notified. So this is kind of a bit more. Notifying is less complex than service of process. You're basically just mailing copies of the notice of hearing and petition to these folks, but it's kind of more people. So who that is, again, I've copy and pasted pretty much directly from the statute. In short, anybody who has had custody or primary care recently, and then close family, if there's a conservator or something like that, or anyone the court says. This is definitely an instance where reading the statute is going to provide the most clarity because they list it out pretty coherently. As I mentioned earlier, there are a slew of additional forms and considerations for, as the law says, when the child is or might be a member of an Indian tribe. I refer you once again, Washington Law Help has a good article that talks about this. Similarly, if you're seeking child support, there's another whole round of forms. More information on that is on the website as well. So you'll fill out the initial forms, copy them, file them, all that. And then you're gonna be given a 60-day hearing checklist that you have to complete. And your 60-day hearing, the court is going to be looking at whether the case is ready to move forward based off these steps. So it's extremely important. Things to consider are if you need a court visitor, which is basically a court intermediary or a guardian ad litem for the child. Whether you need these is stipulated by the statutes, and you'll find information on that what to do next form. This is also ensuring that you've done like the background checks, those DCYF forms, like I mentioned. The form, this can be downloaded off the King County website. I recommend looking at it in advance just to kind of gain an understanding of what the process looks like beyond the initial filings, but you'll be given it, of course. And then based off that 60-day hearings, there are a number of outcomes, right? So the case could be won by default, which means that the other party, none of the other parties, your parents or anybody like that, stepped in and intervened. Similarly, the parents could just sign off on it, and there's less friction that way. Another way, the commissioner could set the case to go to trial, or it could be finalized in another ex parte hearing. So anyway, to finalize the case, there's this findings in order form, which will sum up what the court is ordering. So that was all the procedure for kind of starting guardianship. But what about if you're responding to guardianship? Or maybe you're filing the petition and you just want to know, it would be helpful to know both sides. I think it's worth talking about. Two ways that one can respond. They could, the parent of the minor could agree to guardianship and sign off, or they could disagree, and that's where the case becomes contested. If the parent agrees, they're filling out this consent form, which is it's pretty straightforward, maybe deceptively so, because the minor guardianship has many important ramifications, and unless it's struck down, it lasts until the child's 18. It's pretty permanent. So read it very carefully, talk to an attorney, with more on that on a second. And then the flip side is that there's this form for objecting to a minor guardianship. Similarly, read it very carefully. And if you're objecting, you can also choose to fill out a declaration. This is a general court form, basically an area for you to give your side of the story. So since you'll have to provide copies of these forms on a number of people, you also have to complete the declaration of service that you sent it. Again, who has to receive your copies is whoever filed the petition the proposed guardian, if that's a different person, each of the parents, the child, if they're 12 or older, any person who has had the child in his or her custody recently, also if there's any attorneys involved. Lastly, whether you're consenting or objecting to the guardianship as a responding parent, the court can order an attorney to represent you. This is a big addition to the laws, again, that happened in 2021, where the state basically has to provide counsel for you if your child is subject to a minor guardianship case. There are some caveats and things that need to be checked off, so to speak, but read the forms, read the statutes. You could be able to get an attorney. And as always, there's a matching motion in order to get that done. So I've talked about service of process. What is service of process? Compare that. Remember that sometimes you can just notify people, which is basically just mailing them copies of the documents. But other times, like when you're a petitioner starting the case, you need to serve people, like the parents. I can't go through all the ins and outs of service here in this class, but actually KCLL has a great video on this topic, and it itself is about 10 minutes long, but it's definitely worth a watch. The idea behind service of process is that in starting a court case, guardianship, divorce, civil lawsuit, whatever, it's pretty serious. And the first step of actually letting somebody know that they're being sued, that they're getting divorced, that someone is trying to take guardianship over their kids, we need to make sure that that they've been alerted that this is happening. You can't just shoot them a text or something. There's an official court process, and that is personally serving them. So this is, in short, when a third party, somebody who's not involved in the case, is handing over the documents, and then under threat of perjury is telling the courts, signing off to the courts that they've actually delivered the documents. So this could be a hired process server, somebody that you've hired to do it. There's many firms that do this locally. It could be the sheriff's office. You can pay the sheriffs to serve your documents, or it could just be a family friend, somebody who's not involved in the case. There's a lot more to it than that. Sometimes you can ask the court if you could do service by mail, things like that. But that's kind of seen as a last resort. And anyway, I would send you over to our 10-minute long video to learn more about service of process. Oh, I'm glad I added this slide. So the King County Law Library, a new project that I've been working on is the Family Law Forms Drafting Lab. This is where we have a volunteer attorney come in and help people while they're filling out their forms. It's not for, should I do this? Should I not do this? General legal advice. It's really for, I have the forms that I'm working on. I'm working on this guardianship case. I'm working on the petition, but I don't know what some of these terms mean. As librarians, we're not really in a position to help people look over their forms and tell them they're doing them correctly. Well, we hear that almost every day, and we want to help. So what we did is we got this volunteer attorney to come in once a week, every Wednesday. It's every Wednesday from 2 to 4 in the Seattle location of our library. Folks can come in. It's first come, first serve. And you can talk to an attorney while you're filling out your forms. I think we're like a month into it, so it's still growing. We're still learning the best way to run this. But if you're working on guardianship forms, you can come in and talk to a lawyer while you're working on those forms. And then also the Family Law Facilitators, a courthouse department, they do help with guardianship. So they have walk-in hours Monday through Thursday. You can see here on this slide that it's Kent on Monday, and then it goes Kent, Seattle, Kent, Seattle. So today, Wednesday, they're in Kent. Tomorrow, they'll be back in Seattle. It's great to be able to talk to folks like this who see it every day, and they kind of know the next steps. They can help you navigate the process. All right, we made it to the end of my piece here, 3 minutes to spare, which I think is great. We have Nadia from Ex Parte on hand to answer any questions that I cannot. So we do have 23 minutes, and I'm hopeful we get some pretty incisive questions. So let me open up the Q&A pod and see what we've got.
Ross, we also have Commissioner Moore here. I'm not sure if you could make him a host or a participant so that he can.
Oh, that's fantastic. I didn't know he could join. So let me go over to the participants tab, see if I know how to do that.
Thanks, Russ.
Thanks for joining. So we have 2 questions so far in the Q&A pod. Someone says, do you have to send the order for DCYF to release information to DCYF?
So once you obtain an order for DCYF to release information, which you should do at the time of filing if possible, the clerk's office actually sends the order to the department, and then the department will respond to the court directly. So in most cases, you won't know that the department has provided that information unless you view the docket. You may be able to identify that a sealed document has been filed, but you cannot view it and you will not receive a copy of the results of the background check. So short answer is no, long answer is still no, but also some more information there about how to know whether or not it's been accomplished.
Thanks, Nadia. I love when the short and long answer are effectively the same. Someone asked, could you articulate the difference between notice and service? This looks like probably after my section. So they said, can you clarify the difference between the two? I know that, so service of process is like an official court procedure, like looking at, I think it's CR 5 that is about service. Don't quote me offhand. But there's court rules that govern service of process, whereas notifying, I think in the statutes, I think like certified mail is okay. Maybe Nadia, you can speak more intelligently to that.
This is Commissioner Moore. I can speak to it. Service of process requires that the documents be personally presented to the party to be served by somebody who's not a party, and then that there's a sworn declaration that they got it. Whereas the subpart of the rule that requires notice to other people says you can do that by mailing. So you can put it in the mail and sign a declaration that I mailed these documents to all these folks, but there doesn't have to be necessarily proof that they got it. But service requires that somebody independent of the case actually delivers the property to the person and declares under oath in a sworn statement that's filed with the court that they did that, what it is they gave them, when they gave it to them, and where it happened.
Next up, somebody asked, why are judges requiring petitioners who have filed a minor guardianship case to file an emergency guardianship petition instead of a motion for emergency guardianship?
So, I mean, I don't think we can answer why a separate individual judicial officer might make a decision like that. But I can tell you that there is a lot of confusion, I think, in the public and even to some extent internally about how to go about filing an emergency minor guardianship when there is already an existing minor guardianship. And so, I would definitely encourage you to review LCR 98.22, the updated version, excuse me. And to know that in general, our understanding is that if you have an open existing minor guardianship case and you subsequently decide to file for an emergency guardianship, that you should be able to file a motion for emergency guardianship in your existing case. And then if you need immediate orders, you may also file a motion for immediate emergency minor guardianship in that same case.
No, this is Commissioner Moore. Nadia, can I just add, I think some of the confusion comes from what we have seen happen is folks have an existing regular guardianship case open. They then decide that whatever happens, that they need an emergency immediate guardianship, and they just file the motion seeking the emergency immediate guardianship. And they have to file the petition seeking emergency guardianship and the motion for immediate hearing. Are we right on that, Nadia?
I don't think that's quite right. I think that the answer is that you should not have to file a separate case if you already have.
No, I wasn't saying you had to file a separate case, but you have to file the motion for emergency guardianship. You can't just file the motion seeking an emergency hearing on no notice. You have to file a motion for emergency guardianship and then file your motion for immediate relief.
Yes, I think my understanding of what Commissioner Moore is saying is that in some cases, litigants have come in and filed a motion for an immediate order, and they have not filed any motion for the 60-day emergency guardianship.
That's correct.
Basis for the court to move forward with a longer term emergency guardianship because there's no motion for emergency guardianship, or perhaps there should be a petition for emergency guardianship depending on the circumstances, and that needs to be filed. So I think there's also some terminology changes that everybody is growing accustomed to, such as saying motion versus petition. But I think what Commissioner Moore and I have both said is that our understanding of the rule is that if you have an existing case, you do not need a separate existing case to file a subsequent emergency guardianship. You should be able to file a motion for emergency guardianship in your existing case and a motion for immediate emergency guardianship in the existing case if necessary. We're also often just as confused by these things as you are, or we are all trying to work through them ourselves. And I feel like articulating it is really difficult just because of the number of different names of motions and petitions and so on that we have to use that are all very similar. And I do know that the Family Law Department is working on updating its instructions related to these cases as well. And even if you're an attorney, I mean, I find that reading the Family Law Facilitator's instructions can be very helpful because it gives you a plain English explanation that is generally been approved by the judicial officers that are hearing these types of cases. So I would definitely refer to those as soon as they are available to address these this change in the rule to accommodate the motion for emergency guardianship. And Ross, I just want to really quickly, I know I think we've answered that question to the best that we could, but I did answer a question in the chat and I realize it goes away if it's answered. And I just want to point out that someone asked whether or not DCUIF will send back court CPS records from active open investigations in response to a order to produce or order for a DCUIF records. And I don't know that there's any rule about this specifically, but my experience personally has been when I'm reviewing files, at least, that they do attach copies of information from active investigations to their response, although not necessarily all of them. And Commissioner Moore, I'm not sure if you've seen that repeatedly, but
yeah, that's been my experience too.
Great, thanks for answering that, you guys. Someone asked, wow, the questions are piling up here. Let's see. Can you address the new rules around terminating minor guardianship?
I'm not familiar with any new rules other than the new statute. I'm not sure if there's a more specific question, but if you have an existing minor guardianship, you should be able to file a motion for termination in that case. And that would usually result in, I have to go back and review the rule, but I believe it would result in a new judicial assignment and case schedule. If you have a non-parental custody case, you must first file a petition to convert it to a minor guardianship case type 4 and a petition for termination. And then it will also likewise receive a judicial assignment for review of the termination. But if there's something more specific, a more specific question, then I think if the person wants to put in the chat, then maybe Commissioner Moore or myself could respond.
Yeah, that's a good point. I think it's a big topic and a more specific question. Happy to answer that. The next question somebody asks, what happens when a biological parent of a child older than 4 years old who's not on the birth certificate, what happens when they file a guardianship petition? Does it get kicked over to like a parentage type action, or is guardianship fair play?
So if a biological parent of any child can file a guardianship. I mean, anyone can file anything they want, right? Any person can come into the clerk's office and file, but I believe, I don't have the statute right offhand, but a biological parent cannot be appointed guardian for their own child, at least not consistent with what the RCW says.
Yeah, that's correct, Nadia. The statute says any person interested in the welfare of the minor can petition. And I think that's, we have seen cases where parents petition, for example, someone who's been deployed and they're the sole parent and they want someone appointed for the 2 years they're going to be deployed. So parents can file the petition. And so, I mean, I think the direct answer to the question is whoever files it, it's not going to get kicked anywhere. It's going to get dealt with in the same way we handle any other petition for a minor guardianship.
That makes sense. Somebody asked, if you don't have an address to provide notice, is there an alternative way to give notice?
But depending on what type of case you're talking about, the court has the authority to potentially grant alternative mechanisms for notice, but you would have to file a motion to ask the court to approve that. And there are some limits, which I think may or may not be in the statute, but and are sort of open to judicial interpretation. But if you would like to seek to waive notice or to seek some alternative mechanism for service, you would need to file a motion to accomplish that. Or in some cases, you may need to file something to notify the court that you were unable to serve someone, in which case the court may take next steps, like, for example, appointing a court visitor to investigate whether or not that is in fact, whether or not service is possible or otherwise.
Well, and again, under the statute says, and it's 11-130-195 1B, it says you need to give notice by mail or other action reasonably calculated to give notice of the time and place of the hearing. And so if someone came to my court and said, we didn't mail it because we don't know where they are, I'm probably going to make you continue the case and explain to me and ask you, are there other ways for you to find, like, a grandparent, for example? Are they on social media? Do you have an email address? Those sorts of things, and make the best effort you can. Again, it says any action reasonably calculated to give notice. So if you give notice in some other way because you don't have a mailing address, you're just going to have some explanation to the judicial officer why that's likely or reasonably calculated to give the person some notice that this hearing is happening. And again, just to be clear, this is not personal service. Personal service is different. I assume the questioner is asking about the sort of second category of folks for whom personal service is not necessary.
Yeah, that was my assumption as well. Somebody asked, can you repeat when the drafting labs are held? More information about the drafting labs online. Indeed, if you go to the library's website, which is kcll.org, /events, or if you just go to the main page and click on events calendar, you can see it's every Wednesday from 2 to 4 in the Seattle location. So it's every Wednesday from 2 to 4 in the Seattle location. Somebody asked, how long does it take to receive letters of authentication after filing an acceptance of appointments? And is it more beneficial to have the letters when traveling, applying for benefits on behalf of minors, as opposed to just using the signed guardianship order?
So how long it takes to receive the letters just depends on how you've requested them from the clerk's office. Just the order itself approving the issuance of letters means they'll be in the court file. It doesn't mean that you would receive a copy. You'd have to order them from the clerk. You can do that online or in person. If you did it in person and everything was in order, you would receive them immediately. If you do it online, I don't know, Yvonne, if you wanted to chime in, but I think it just depends on kind of what the workload is. I think the expectation is usually within a short number of business days But you go into a queue, right? Depending on how many people are in front of you in the queue. And then I believe that the statute specifically states that the letters of guardianship or the letters of office are what give you the authority to act. So generally that would be the document that would permit you to make decisions or to show to law enforcement or medical provider, et cetera, that you are in fact the guardian. If it were me, just anecdotally, I'd probably carry both documents just in case. But technically the letters of office are what give you the authority to act on behalf of the child.
Great.
And then it actually takes 24 to 48 hours for the letters to be issued and available on the portal for customers to request. And once the customer makes the request through our portal, it will take approximately 3 business days for us to provide their requested document.
Great. Someone said, regarding e-filing, which documents to file with ex parte? What to file together with the petition or as attachments to the petition? I think that is largely going to be addressed by the type of case, and looking at, the Family Law Facilitator's packets, it's going to list out specifically which forms. Maybe the whole attachments or which documents are going to ex parte. Nadia, maybe you could speak to that. But I think that those lists provided by the facilitators are the best starting point. Someone said, for the motion for emergency guardianship, would the notice be noted via emergency motions or noted for the 14-day after filing?
So this is kind of confusing, right? So again, if you already have an existing guardianship case and you are then filing a motion for emergency guardianship, what you are saying is, what you're telling the court is that a guardianship is necessary, an emergency guardianship is necessary for a minimum of 60 days until a regular guardianship can be entered, potentially indefinitely. If you file just that and there's no emergency, meaning there's no immediate emergency, the child will not be harmed or is not subject to abuse or what have you, until you can have a hearing with the judge, then you need to note that for 14 days notice on the judge's Friday calendar. If you are asking the court for an order to be entered immediately, meaning like that day, for example, that would be noted on the emergency motions calendar. So it depends on the circumstances of the individual case. Does an order need to be entered, or would you like to ask the court to enter an order immediately because there's a true legal emergency, or is it that you need a long-term temporary guardianship, I guess would be another way of looking at it, in which case you would note it with 14 days notice on the judge's calendar.
Great. Someone asked, is it still necessary to file 2 separate cases if the case involves children with different parents? For example, grandparents are seeking guardianship of 2 children that have the same mother who has the custody of the children, but there are 2 different fathers.
Absolutely. Any case that doesn't involve the same children must be filed in separate case numbers.
Yep.
Bearing in mind that in each of those cases, there are other family members that are entitled to be notified, like grandparents and brothers and sisters and so on and so forth, that will be different for each child. Even if the other parent doesn't have custody of the child, those other people are still entitled to be served. And so they will move forward in their own separate matters.
Yep. We're at time, or I guess we're over time. But there are 2 more questions if Nadia and Commissioner Moore, if y'all are able to do those. This question says, when a current guardian and standby, formerly known as successor guardian, decides to switch roles simultaneously, is it acceptable to file motion and order outlining the changes in the same motion and order as opposed to drafting separate pleadings for each role change? Also, the order appointing the guardian or order does not have a section for bond. Hence, is it acceptable to add language such as bond is waived? Thank you.
So I think that this question is about adult guardianships potentially, because they're the standby guardian role in a minor guardianship is different. And I don't think, And there is no bond in minor guardianship cases because they don't involve authority regarding a minor's assets. That would be a minor conservatorship, which is a different type of a case. I think that though, just generally speaking, that if something is required in the law and there is not a section on the order, well, there should be a section on a mandatory form for anything that is required in the law. But otherwise, if you are asking the court for something, then you can add that under other, as long as it's addressed in your motion. And then the court will make a decision about whether or not that's appropriate.
Great. Last question. Someone asked, when are court visitors required?
I can answer that, Ross.
Great.
I mean, you just look at RCW 11-130, 195, sub part 4. There's 3 situations in a minor guardianship when a court visitor is required. In all cases where the minor is over 12 years of age, excuse me, and unrepresented by a lawyer. All right. And if they allege that either parent is unable to be served with due diligence, and finally, we take the position that if you have a parent who's consented, that you claim has consented, that we have to appoint a visitor to confirm consent. And let me add, I forgot the other one. If a parent, if the petition alleges that one of the parents has waived their right to notice, then we have to appoint a visitor as well. So it's all laid out in subpart 4 of 11-130, 195.
Perfect. All right, 17 questions answered. I really appreciate everybody taking the time to listen to the presentation and for all the great questions. I'm appreciative to Nadia, Yvonne, and Commissioner Moore for joining. No more open questions for now. So again, thank you, and I hope you have a good rest of your day.